Hi, I'm Steve Carlson, and I filed this appeal today in the Minnesota Supreme Court regarding the funny business that Al Franken and Mark Ritchie and Mark Dayton have gotten into with their illegally issued certificate. And as you see from what I'm going to read for you that I filed with the Supreme Court, the panel that they appointed has got involved to try to buttress the wrongdoing by Franken that has him out there in the Senate based on an illegally issued election certificate under Minnesota law while a contest against him was still pending. And that needs to be remedied, and that's what this motion is all about, to void what he's done and what the state has done, and to go back to Minnesota law, and that would include invalidating the certificate that he presented. Now, he'd still be in the Senate because the Senate seated him, and that's not the issue here. The issue here is Minnesota's law being followed? What could come out of this is the invalidation of his certificate and requirement that he be recertified with the state through a contest, which involves some very important issues of serious, deliberate, immaterial violation of Minnesota election law, irregularities in the conduct of the election, the U.S. Senate election in 2014. Please take notice that contestant Stephen W. Carlson hereby takes appeal to the Minnesota Supreme Court from the panel's order of March 27th, 2015 attached. Pursuant to 20910 subdivision 4, contestant Stephen W. Carlson appeals the attached ruling of the three-judge panel appointed by this court in the matter of choosing a U.S. Senator from Minnesota in the 2014 general election. Said ruling denying contestants' February 4th, 2015 post-judgment motions. And the order calls this motion post-appeal, but in fact, since the required procedures of 20912 were never followed, there has been no final determination to appeal, except to decry the irregularities of the proceeding and the refusal of the panel to allow the contest to proceed in any recognizable form as a contest. In any event, the only thing that has been appealed has been the preliminary order signed December 18th and entered December 19th, 2014. As Secretary Ritchie said in his January 5th brief to this court, none of the order of December 30th, 2014, which supposedly closed the contest, has ever been appealed. Again, there is nothing to appeal, and what is appropriate is to void this proceeding and collect the full record, as well as evidence on the points actually raised in the contest, and forward it all to the United States Senate. And so this was filed in district court. I did pursuant to Minnesota Rules of Civil Procedure 52, 59, 60, and 62, requesting the panel to vacate the December 19th and December 30th orders, and one was entered as a partial judgment in violation of the election contest rules as void, and invalidate the certificate of election issued to Franken, that it amend its December 30th order to strike certain facts and conclusions of law because they're not permitted to issue them, and that it grant a new trial, and that it stay the operation of the judgments. Contestant further asked his court to remand the contest back to the panel or another appellate body for a proper proceeding under 20912. Here are the grounds. Contestant Senate nominee 2014 Stephen Carlson files this appeal from the denial of post-judgment motions by the panel appointed by this court on the grounds that, first, the proceedings to date violate the United States Constitution, sections 4 and 5 of Article 1, and have frustrated the Senate's ability to make an independent judgment on the issues within its jurisdiction, including but not limited to the decision to seat Al Franken or not, and the Senate may also use this contest and its record to discipline or expel Franken or to regulate Senate elections in the future by using its own powers under Section 4 of Article 1 of the Constitution, which says, but the Congress may at any time, and I'm going through footnotes here, may at any time by law make or alter such regulations, as we're talking about a code that's going to be set up in each state, and the Congress can come in and pass laws to regulate that. And this court should not make these decisions for them, and the contest is not moot. In other words, this is something in the Senate's jurisdiction, not any Minnesota court. Further, therefore, the remedies to these violations, including voiding these proceedings and remanding them back to the panel or some other appellate body selected by this court, are appropriate and necessary to safeguard the fundamental rights at stake in a U.S. Senate election and election contest. The order number 2 unconstitutionally violates due process as established in the contest provision. 3, the order departs from the solid principles and precedents of Minnesota's complete congressional election code as established in the 2009 case Franken versus Pt I. Now that's court docket A09, appellate A09 from 2009-64, Minnesota 2009. Also violates Smiley versus Holmes principles and precedents, Rodebush versus Hartke, Minnesota statutes 209.02, 209.12, 204C.40, Morgan versus United States, and Nixon versus the United States. 209.02 gives grounds on which a contest against L. Franken can be maintained. And contrary to what this panel has said, it isn't just about the vote count. It's about irregularities in the conduct of the election. It's about serious material, deliberate violation of Minnesota provisions of Minnesota election law. And 209.12 is the contest provision, which again, if these are raised, which I did in my notice of contest, these need to be, evidence on these needs by Minnesota courts to be collected and sent to the United States Senate for them to decide. And this was not done, and it needs to be done now. And 204C.40, the contest tolling provision, as I said, will bar the issuance of any certificate whenever a contest is still pending until it's finally determined. Now, on December 19th, one day after the so-called trial on December 18th, well, that afternoon they signed a preliminary order, but that was a partial judgment. There's no way that the contest was finally determined on that date, and yet they went ahead and issued that. And you'll see that the panel, consisting of 3 judges, one from Hennepin, one from where I am now, one from Ramsey, and one from Anoka County, 3 big voting areas in Minnesota, presided over that. And what they're trying to do is to explain how it is that the governor, Governor Dayton, could have issued a certificate illegally under Minnesota law. And they're trying to come up with different stories, different could-be scenarios to explain why there's clear violation of law. But really what this issue about is, what can we do about it now? And I'm saying void it and go back and collect that evidence, send it to the Senate, and we'll go from there. Let's follow Minnesota law. We can still do it. If we don't, I will appeal to the U.S. Supreme Court. But let's talk sense. Let's talk common sense. Let's protect Minnesota's election laws. It's more important than just one party or just one candidate. It's about our democracy fundamentally. Further grounds, specifically the panel errs where they find referencing the court's, this Supreme Court's finding in Franken versus Pt I 2009, that in Minnesota congressional contests are, quote, statutorily limited, unquote, to finding which candidate received the highest number of votes legally cast, and is therefore entitled to receive the election of certificate of election. Now, I did not challenge how Franken's votes were counted, how my votes were counted, or how McFadden's or anybody else's votes were counted. That is not what this contest is about. But that doesn't mean it screeches to a halt. Secondly, they err when they purport to find a temporal mandate requiring the issuance of that certificate by a date certain, because that's going back on what they told Franken in 2009 when he was suing his way into the Congress past Norm Coleman. And C, The panel further errs where they purport to find that the temporal mandate they see required and actually affected a suspension or triggering of the contest tolling provision on December 19th, 2014. So in other words, if there's a temporal mandate, does it really require that certificate issue? Well, of course it doesn't. And this was done December 19th when Governor Dayton and Secretary of State Ritchie signed, countersigned, and sealed an election certificate in violation of Subdivision 2 of 240C.40, which permits that issuance only when the contest has been finally determined, because it had not been finally determined. Any contention that this court's January 5th, 2015 order finally determined the contest is irrelevant, since it could not have lawfully triggered the December 19, 2014 release retroactive. All the panel's issuances constitute continuing impermissible judging by those who are expressly excluded from judging this contest. See Morgan versus United States. The only judges in this contest is the U.S. Senate. And now in this order, these judges are stepping in and trying to protect Al Franken and his Democrat colleagues from the requirements of a contest as established independently by the Minnesota legislature in enacting the election code for members of Congress. And they are attempting to apologize for and explain away the obviously illegal issuance of Al Franken's election certificate December 19th, 2014. Now, this continuing and improper meddling by the panel, and sometimes this court, the Supreme Court, in that election contest renders it voidable for the reasons set forth in the motion to the panel to void the contest and its judgments, and to void Al Franken's certificate so that Minnesota will be properly represented under law in the U.S. Senate, and to direct recertification under the contest statute and related statutes. And Subdivision 1 of 204C.40, I've talked about Subdivision 2, contemplates the invalidation of an election certificate during a contest, and that should apply here, so that under Subdivision 2, identical, a new certificate should issue at the conclusion of the contest. And 6, voiding the proceedings at the panel is consistent with and promotes the purpose of Minnesota's Congressional Office Election Contest provision. And I call this the CCEC, that's the Comprehensive Congressional Election Code. Every state's got to have it. It promotes it generally because the contest addresses all questions regarding Franken's right to office. And that disposition under 209.12, that is the contest provision that's supposed to be carried out, but has been stymied, blocked, and buried by the state officials, and Franken as described infra, and on all the records, files, and transcripts and proceedings. So this should be, this has got to be voided and brought back down to earth. And Franken, like I say, can still stay out there, but we have to make sure his certificate is valid. That's the Senate's own rules. Now, the panel has denied the motion to void and recertify Al Franken and or the person selected under Minnesota law correctly this time. Contestee in this appeal requests the court to remand this contest back to the panel or some other appellate judge to be properly completed and consummated under Congressional Office Contest Provision 209.12. Memorandum of Law. The motion to void the panel's proceedings is totally consistent with and promotes the purpose and structure of the Comprehensive Congressional Election Code. And I consider that includes chapters 200 to 212 of the Minnesota statutes, that's called elections, and all other provisions in the Minnesota Code, including notably the constitutional and statutory provisions set forth in the Notice of Contest. The Minnesota Government Data Practices Act, as it applies to the public nature of the voter email addresses collected by the Secretary of State, and as I've said, used by him to fund his own campaign and that of the Democrats, but denying that to me, even though for 2 years, or for years, they say, that he'd been made available to people. Now, as well as required U.S. constitutional provisions set forth in there, and federal statutes and regulations, including the equal time provisions, regarding publicly broadcast debates as set forth identical. So what I'm saying is that all of this is part of the Minnesota comprehensive congressional election code. Now, continuing then, this is packed with information. And this is established by the framers. The authorization under Article 1, Section 4 for the states to prescribe the times, places, and manner of holding elections empowers the states, according to this U.S. Supreme Court case from rather recently, I think it's just like 2004, but it empowers the states, quote, to provide a complete code for congressional elections. I call that the CCEC. That's from Rodebush, and it's citing Smiley versus Home, which is a Minnesota case in which Chief Justice Hughes of the United States Supreme Court first set out the broad scope and broad grant of authority to the states under which these contests operate, and so does the entire election code. All of our election law operates under the broad grant of authority from the United States Constitution, not from anything here in Minnesota. And this was cited in Palenti at Section 2. Now, the court concluded that a recount is, quote, an integral part of the Indiana, that case, electoral process, and is within the ambit of the broad powers delegated to the states by Article 1, Section 4. Again, from Rodebush. Now, this is something that Al Franken has had a problem with since 2009, and his lawyers have attacked this ferociously, so that it helped him get in 2009. Now, and this is also set up by the Minnesota legislature acting in the capacity enumerated in Article 1, Section 4 of the U.S. Constitution, which says the times, places, and manner of holding elections for senators shall be prescribed in each state by the legislature thereof. And as such, the panel's further disfigurement of that code in its March 27, 2015 order purporting to restrict congressional contests under 209.12 to the question of which candidate for office received the highest number of votes legally cast. And they said in their order, in statewide elections for congressional office, the scope of the contest is statutorily limited to the question of who received the highest number of votes legally cast in the election, unquote. Apparently, this applies only to the U.S. Senate races, according to this odd and novel view, because that's the only statewide congressional election. The ones for congressional districts 1 through 8 are not statewide. Now, as such, the panel's further disfigurement, as I said, it does attempt to limit it, and it also purports to establish two preeminent purposes, supposedly reserved for Minnesota courts, like this panel, like the Minnesota Supreme Court, by the Minnesota legislature in passing this CCEC. And what they say is the procedures reserved to the courts by the Minnesota legislature with respect to congressional election contests are clearly designed to effect a prompt and decisive issuance of a certificate of election based solely on a count of votes, reserving all other issues in the notice of contest, including the seating of a candidate, for determination by Congress, unquote. Well, this is obviously inaccurate, since even the count of votes is reserved for determination by Congress and not any Minnesota court. The Senate can conduct their own count or accept the canvassing board or Minnesota court's determination. Further, 204C.40 subdivision 2, which I've already mentioned, prohibits the governor from issuing the certificate on terms urged by the panel. The secretary, and they are without power to do anything but comply with the law, the judges, and not to authorize the governor and secretary of state to disregard the restraints of this political law and just issue it based on their own terms. And that's what they've done here, and that's what has to be fixed. I don't think anybody really believes the law has been followed. They just think, well, if we can't justify it, how are we going to fix it? What do we do now? And that's what I suggest here. Now, these erroneous misstatements about the CCEC are actually dangerous to democracy and will render impossible the rule of law in constituting our democratic republic. Now, under the Minnesota Rules of Civil Procedure, as discussed in relation to Rule 81.01, the issue is what civil remedies under the civil procedure are available to consummate this contest under the CCEC, which I call Section 4, and under Section 5, and whether voiding the panel's proceedings thus far is consistent with the CCEC and Section 5. Now I want to explain what Section 5 is. Section 5 of Article 1 of the Constitution says that the Senate itself is the sole judge of their elections, qualifications, and returns of their members. And so nobody can tell the Senate what to do. And that's a very old principle. This isn't in the brief, everybody knows this. Where that principle comes from olden times in England, where the first time they got a parliament to be elected, well, that's good, but if you have a king, he's so powerful that he would go and mess around with the elections, just like these national parties and Al Franken go around and mess with our elections. And so he would actually tell them who was going to be in their parliament or their Congress. And we do have this problem all around the world right now. There's something unique in United States government where the people are able to directly elect their representatives rather than have them handpicked or appointed by a king or another powerful central figure. And one of those big central figures is the Democratic Party, and in this state, the DFL. And Al, he can even be just a funny guy, and he just floats in, doesn't know anything about the law, obviously, but he can buy these people and give this money to the Democrats, and they can tell you who's going to be in the Congress rather than us electing them. And the Republicans are the same. Any kind of powerful national committee, even if it was even in this state, the Independence Party has its own bureaucracy that tries to tell people what to do. So the independent voters can't elect people based on an informed choice of what their policies, positions, and qualifications are. They have to be handpicked according to certain issues and drugs and religious liberties versus homosexual rights. These have been the litmus tests on which that party has decided who's going to be elected. And of course, nobody has been elected by that party, but yet we need that vehicle for the Independence Party, independent voters. So I just wanted to explain what is Section 5. It's that part of the Constitution that allows the Congress to determine who won and who didn't win. Not some courts, not any kind of distant figure, because they jealously guard their ability to ensure that they're democratically elected. And this is on the Senate. The Senate has to step up now. They need to look at this. They've been informed of this. I've been sending this to the Senate and their staff and people who watch the Senate, all the senators, not just Amy Klobuchar or Al Franken. The entire Senate needs to look at this. So Section 5 is really very important, but so is Section 4, which is our state, allows us to set up our own rules. I'm going to real quick look at the time on this. This is 23 minutes. I'm going to continue with this for a while. Now, I agree, I argue, that is to say, that it is consistent and promotes the purposes of the contest provision to void those proceedings and replace them with a proceeding that actually conforms to Minnesota law and not to illegally issue a certificate for Al Franken. Everybody by now knows this. I mean, the panel comes back with some very weak arguments about, well, we didn't really follow 204C.40 subdivision 2, but then, we don't have to. And that's very dangerous, as I say, for democracy. And so I argue that voiding it is consistent with the provision. They argue that it's inimical, that it's antithetical to the contest provision set out in our law. And I will get right into that and show what it says and what the Supreme Court said it says and what they told Al Franken it says. And there's a little bit of murkiness there, but it's pretty clear that it's not limited to just a vote count, as this panel handpicked by the Supreme Court, Chief Justice Lori Gildea, has come back with. And I also argue that the proceedings at the panel, as I'll explain, were deformed by the actions of L. Franken, supported by Mark Ritchie, ignoring the contest law as explained to Franken in Franken versus Palenti, 762 Northwest 2nd, 558 at 569. That's from the Minnesota Supreme Court, who this is coming to. It's an election petition brought in 2009. The 2014 contest included a motion to dismiss the contest entirely, using Rule 12 of the Civil Rules of Procedure. Then just to dismiss the contest of the first two sentences of 209.12, apparently relying on the amendment procedures, and then a preliminary order using Rule 54, which was understood apparently by Governor Dayton and Ritchie and Franken as allowing the issuance December 19, 2014, of the election certificate to Franken while the contest was pending in violation, clear violation of Minnesota law. So they've been abusing the point here, they've been abusing the rules of civil procedure. But now they're saying, stop, we can't fix this using the rules of civil procedure. We could ruin it, we could thwart it, block it, but we can't fix it. Well, of course, we can and must fix it using the rules of civil procedure. And so only the issuance of this preliminary order where they, under Rule 54, was brought to the Supreme Court on December 26th, and apparently that was filed December 30th. But I only received the preliminary order in the mail on December 23rd, and so that was a very prompt response within 3 days right after Christmas and before New Year's Eve, or New Year's holidays. But the documents were also sent to the United States Senate Secretary in an attempt to notify them and enable them to have information to make an independent decision on these matters. But it can't be argued that somehow that fulfilled the requirements of Minnesota law. Your order, January 2nd, which they sent to me, came in the mail following the New Year's weekend on January 5th. And it was not feasible to fulfill the requirements of Minnesota law before the Senate acted January 6th. But the issue has never been the seating of Franken, but whether Minnesota contest law is being followed or thwarted. And the record shows Franken has thwarted it. Try to say that real fast 5 times. With the support of Ritchie and Dayton. And the issue is, what is the remedy? Now the panel wants to put its foot down and deny the use of the voiding provisions in the civil rules and provisions for either new trial or amended findings under civil rules, or perhaps remand by this court to the panel with instructions to proceed following the contest provision, please, and to invalidate Franken's certificate. The contest has not been appealed. Only the matter of the early release of this partial judgment. As such, this is not a post-appeal motion. The procedures were deliberately not followed by Franken, the panel, and even this court, see infra. But the departure from procedure, which was at the heart of my December 26th appeal for mandamus, was not done openly but covertly. Only now in this order has the panel revealed their thinking and tried to buttress the release of the election certificate by the governor to the Senate December 19th. The Attorney General has argued March 23rd, 2015, that this deviant procedure was actually mandated by 209.12. I show here it is not, and is contrary to law, and even contrary to the Palenti decision, see info. Now the panel invokes 81.01 to rule erroneously that voiding procedures are not available under the CCEC because it is supposedly inconsistent with the proper function of the contest statute. They're saying the contest limits everything just to the vote count. All that other stuff in the contest provision, ignore that. We're not going to do that. But they ruled, and you referred this to them to adjudicate, that a motion to dismiss the contest, which can only be interpreted as a motion to disregard and refuse to follow the CCEC, is somehow not inconsistent with the election contest provision and the CCEC generally. This is cherry-picked to judge and therefore create a particular outcome in a U.S. Senate contest. Powers reserved only to the U.S. Senate because they are not to be found in the CCEC itself. There is no reservation of such powers discernible in the CCEC to the courts of Minnesota. And the panel has failed to show any authority for this claimed discretion, and it violates sections 4 and 5 of Article 1 of the U.S. Constitution. On the other hand, voiding a proceeding like this is not only permitted, but required, if in fact, as Justice Hughes said, Chief Justice Hughes of the U.S. Supreme Court, the Minnesota legislature had the power and concomitant duty to enact the numerous requirements as to procedure and safeguards which experience shows are necessary in order to enforce the fundamental right involved. The voiding provisions in post-judgment motions, which are part of state law, must be understood as part of that CCEC, because they are not only not inconsistent, I should say, but a required safeguard for election integrity. And this can be understood together with the appeal procedures if this court will understand the purpose of the contest provision 209.12. If it is followed, the only kind of appeal that conceivably could be had would be that part which has been committed reserved to the panel to make a finding and conclusion of law with respect to the vote count. And you upheld this in 2009. That's all that can be appealed in Pawlenty. All other parts reserved for Congress in terms of other points raised in the notice that call into question Franken's right to office or irregularities in the conduct of the election are by definition never appealable, since they can't be decided by the panel. Clearly, the appeal provision refers to decisions the court could make and not those that are prohibited, and that is the only appeal provided for. And again, the count is not challenged in the contest, but the true contest substance is within the ambit of the CCEC, and the contest should proceed. Perhaps the panel is trying to suggest that it is only in this case that there are no points beyond the vote count. They can't come out and say, this notice is about things the Senate could never possibly be interested in seating or excluding Franken, and the Franken voters will be outraged if we allow this contest to proceed. They can't say this because it's not in their ambit. Section 4 simply has not conferred any such powers or jurisdiction on them. And so firmly, they acted beyond their jurisdiction when they disfigured the CCEC as I describe here, particularly 209.021 subdivision 3, the Secretary Ritchie's frivolous motion to be dismissed, 209.12 allowing a contest or dismissal thereof on the first two sentences of the provision alone, and 204C.40 subdivision 2, suggesting it was proper for Dayton and Ritchie to issue the Franken certificate even though the contest was still pending. And I'm just going to leave it right there, and in the next video I'm going to come in with the summary and introduction of the argument and just set out for the world what went on here. It is incredible. It is a spectacle. I don't think this has ever happened in the history of the U.S. Senate, and I certainly hope it never happens again. But we need to fix it now. I'm Steve Carlson, and I approve this message.